Maryland House Bill 1000, and Maryland Senate Bill 1040, also known as using spidey sense to restrict citizens' rights in violation of the U.S. Constitution. The bill's objectives are to prohibit individuals from possessing firearms or obtaining a concealed carry permit based on the terrorist watch list. The terrorist watch list is a database and is actually not a watch list at all. It is designed as a series of folders for the collection of information regarding an individual that may, through data collection and analysis, rise to the level of a possible threat for inclusion on the no-fly list or further investigation. Inclusion on the list itself does not result in an investigation or even rise to the level of reasonable suspicion. So let's talk about different levels of evidence. The first one we'll discuss is probable cause. This is the standard by which police authorities have reason to obtain a warrant for the arrest of a suspected criminal. The standard also applies to personal or property searches. Probable cause, in conjunction with a preponderance of the evidence, also refers to the standard by which a grand jury believes that a crime has been committed. The term comes from the Fourth Amendment of the United States Constitution, which states, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." Probable cause is the minimum standard required to deny or restrict an individual's rights and must be supported by due process. Due process, as guaranteed by the Fifth Amendment, requires that no one shall be deprived of life, liberty, or property without due process of law. The 14th Amendment incorporates due process as a legal obligation of the states. Due process generally requires the following elements, none of which are afforded to individuals under the subject bills: an unbiased tribunal, notice of the proposed action and the grounds asserted for it, an opportunity to present reasons why the proposed actions should not be taken, the right to present evidence, including the right to call witnesses, the right to know opposing evidence, the right to cross-examine adverse witnesses. The decision of the tribunal should be based exclusively on the evidence presented. The opportunity must exist to be represented by counsel. There is a requirement that the tribunal prepare a record of the evidence presented, and a requirement that the tribunal prepare written findings of fact and reasons for its decision. So what is reasonable suspicion? Well, this is a legal standard of proof that is less than probable cause. It is normally sufficient to justify brief stops and detentions of individuals, but not enough to justify a search. Cannot be used to restrict an individual's rights. It must be based on specific and articulable facts. It must be associated with a specific individual. Reasonable suspicion is evaluated using the reasonable person or reasonable officer standard, in which said person in the same circumstances could reasonably suspect a person has been, is, or is about to be engaged in criminal activity. The last legal standard we'll discuss is spidey sense. It's not really a legal standard of suspicion or proof. It is the basis for inclusion on the terrorist watch list. It cannot be used to detain, arrest, or restrict an individual's rights. It is derived from the comic book superhero Spider-Man, and is generally used to mean a vague but strong sense of something being wrong, dangerous, or suspicious. For example, he looked like a student, but something about his dirty shoes and the way he tried to open a locked door totally set off my spidey sense.
My spider senses are starting to tingle.
So now let's hear what the Department of Homeland Security has to say about using the terrorist watch list to restrict gun rights.
All right. I guess my concern with this is there have been a lot of talk recently about using these watch lists for purposes other than they were intended. For instance, in determining whether or not Americans are able to exercise their rights under the Second Amendment. Do you think it's appropriate that these lists be used outside of what they were designed for?
I've not heard that, and I don't believe that it would be and I believe it would be apples and oranges.
All right, thank you very much.
The director of the FBI believes that the procedures in place are more than sufficient and disagrees with using the terrorist watch list as a mechanism to restrict gun rights.
Last week, our president stated that there are individuals who can't get on planes, but they can go to a gun shop and buy a firearm, and quote, and he said, nothing we can do to stop them. But, and correct me if I'm wrong, the FBI is notified when someone on the terrorist watch list attempts to purchase a firearm, and a NICS check is requested. And the FBI has multiple avenues that they can pursue. These are some of these avenues. Delay the firearms transaction, and if the person is actually a terrorist, the FBI can arrest them for any crime for which there is probable cause. And in addition, the FBI can intervene and directly confront the individual. The FBI can also put the suspect on what's called around-the-clock surveillance. My question, aren't these some of the tools available to the FBI to stop a suspected terrorist from buying a gun?
Mr. Chairman, you're right. There are a variety of things that we do when we are notified that someone on our known or suspected terrorist database is attempting to buy a firearm. The FBI is alerted when that is triggered, and then we do investigation to understand, are there disqualifiers that we're aware of that could stop the transaction? And if the transaction goes through, the agents who are assigned to that case, to that subject, are alerted to it so they can investigate.
Yeah. I thank you very much for that clarification. So there are then actually many things that can be done right now to stop someone on the no-fly list from buying a gun. And then that leads me to say that our president is misrepresenting the facts.
Now I suggest that you listen to the arguments that will be presented when this bill ends up going to court.
Let me ask you another question about the terrorism list. What process is afforded a U.S. citizen, not someone who's overstayed a visa, not someone who crossed the border without permission, but an American citizen, what process is currently afforded an American citizen before they go on that list?
I'm sorry, there's not a process afforded the citizen prior to getting on the list. There is a process should someone feel they are unduly placed on the list.
Yes, there is. And when I say process, I'm actually using half of the term due process, which is a phrase we find in the Constitution, that you cannot deprive people of certain things without due process. So I understand Mr. Good's idea, which is wait until your right has been taken from you, and then you can petition the government to get it back. I understand that that's his idea. My question is, can you name another constitutional right that we have that is chilled until you find out it's chilled, and then you have to petition the government to get it back? Is that true with the First Amendment?
Sir, there are strict criteria before.
That's not my question, ma'am. That is not my question. My question is, what process is afforded a United States citizen before that person's constitutional right is infringed? Then he's fine with doing it with the Second Amendment. My question is, how about the First? How about we not let them set up a website or a Google account? How about we not let them join the church until they can petition government to get off the list? How about not get a lawyer? How about the Sixth Amendment? How about you can't get a lawyer until you petition the government to get off the list? Or my favorite, how about the Eighth Amendment? We're going to subject you to cruel and unusual punishment until you petition the government to get off the list. Is there another constitutional right that we treat the same way for American citizens that we do the Second Amendment? Can you think of one? Can you think of one?
I don't have an answer for you, sir.
So what are the responsibilities and obligations of the Maryland Legislature? They should only enact laws that comply with the U.S. Constitution. They should strongly consider the significant legal expense and burden that enacting an unconstitutional law will place on the state. They should only enact laws that are based on factual information, not political bias or political party appeasement. Maryland House Bill 1000 and Maryland Senate Bill 1040 are unconstitutional and unnecessary legislation that should be opposed. Thank you.